this is James Ferrell with the Maritime and Mesothelioma Law Group. I would like to talk to you a little bit about a frequently asked question. Is there workers' compensation for maritime workers? And that depends largely on what you're doing. There is workers' compensation under the Federal Longshore and Harbor Workers' Compensation Act. And that is a system administered by the Department of Labor that basically insures and accrues workers' compensation benefits to harbor workers. And most of those workers will be working, like it says, in harbors or in ports where they're unloading and loading from ships. In this case, these workers that fall under the Compensation Act will not necessarily be permanently assigned to a certain vessel. Now, there's another act that we've talked about, a federal act that was enacted in 1920, commonly referred to as the Jones Act. So if you don't fall under the Harbor Workers Act, there's a good chance that you'll fall under the Jones Act. The Jones Act is different because it protects seamen. In order to be a seaman, I have another video that talks about this in detail. You have to be assigned to a vessel. A vessel has to be in navigation, which simply means that the vessel is moving on navigable waters, including an ocean, a river, a harbor. It can be inland, it can be in a canal, and that you have to, again, be assigned to this vessel for more than 30% of your work time. So in that situation, you would be able to not recover under the Longshore Harbor Workers Compensation Act, but you may be able to recover under the Jones Act. Now, the Jones Act provides different types of compensation. If your employer is negligent, even if they're only 1% negligence, you can recover under the Jones Act. Now, that's called the slight negligence standard. In addition, the employer's negligence can be almost anything that causes a danger to the employee. It can be not providing sufficient crew. It can be not training crew properly. It can be dangers on the ship and its equipment. It can be not providing safety equipment. It can be any number of things. So the Jones Act is really loaded to help protect an employee against any negligence of the employer. There's also another benefit that might accrue to a seaman called a Seaworthiness Act. And that simply means that the employer has not provided a safe place to work. And under seaworthiness, if there are defects in the vessel, whether the equipment is not working, or even the fact that it's not manned by experienced personnel, or there's not enough training, you can also file a seaworthiness claim. Now, last and not least, but maybe most importantly, there's also maintenance and cure. And I have a full video on this, but without fault of the employer, if you are injured on a vessel, you're entitled to maintenance and cure, which means you're entitled to rent payments, house payments, taxes, and food. And you're also entitled to pick your own doctors and to get medical treatment if you're injured. So although you may not be entitled to compensation under the Longshore Harbor Workers Act, you would be entitled, if you qualify for seaman status, you would be entitled to these other benefits. So again, this is James Ferrell with the Ferrell Maritime and Mesothelioma Law Group. Thank you.